Hello, my name is Martin Rosenfeld. I am a family mediator, a divorce mediator, an attorney as well, and my practice is in Fair Lawn, New Jersey. My website is njmediationworks.com. I'd like to talk at this time about a new phenomena in the divorce practice, and it is the phenomenon of attorneys who call themselves collaborative law attorneys. What collaborative law means is that a party and their spouse will make a decision. They will not litigate, at least not in the first instance, their divorce. Neither do they, for whatever reason, choose to mediate, go to a professional mediator and to seek the art of mediation in their matters that need resolution, but they go to two attorneys. Husband has an attorney, wife has an attorney. Attorneys make an agreement between them, and the agreement is that neither party will go to court under any circumstance. If they cannot reach an agreement with the parties, the two attorneys are bound to withdraw from their service as attorneys and then leave it to other parties. The hope, of course, is that through the service of these two attorneys, through their advocacy, through the use of some professionals that they may bring into the process, a proper resolution of the issues will be found. I do not believe that collaborative law is something that should never be pursued. I think it has its advantages. I do not, however, believe that it has advantages over mediation, and I will explain why. Firstly, mediation is far less costly than would be the case through collaborative law process. Secondly, it is much quicker a process. The reason for that is because of the fact that with the mediator, you have three schedules that have to be worked out: husband, wife, mediator. With the process of collaborative law, you have husband, wife, attorney, attorney, at times divorce coach, and at times accountant, therapist, what have you. So there are many matters that need to all be juggled during the process of collaborative law, whereas with mediation, the process is streamlined and much more effective. But I will tell you why I think mediation makes more sense from the standpoint of effective communication. When a person goes to a mediator, they are taught to be candid. They are taught to explain what they want and why they would want to have that particular goal met. For example, a person in mediation would not simply say, "I'd like to have more alimony." They would be asked, "What is it that you're concerned about? Why would more financial support in the form of alimony help you plan for your future?" So the parties are basically taught to communicate, to try to explain to another party, who at that time becomes educated as to why husband or wife wants what they want. Most importantly, and for me is most significant, when parties have communicated in the course of their divorce, which can never be done through collaborative law, it's done through the office of the attorneys, not physical office, but the figurative office of the attorneys, they have not learned to communicate to one another. If future problems should develop, they have had no real experience of communicating, of talking. When a person has learned to use the skill of mediation, which is really something that the mediator is shaping for them by allowing the parties to communicate, they will always be able to use that skill and that tool. In my agreements with the parties, my divorce agreements, I often put down that all future disputes will be resolved through either mediation or arbitration. Litigation is not something that needs to be pursued if cost or time or trauma or well-being of family members is at all a factor. I think it's true for all of us that cost and time and trauma and well-being of family members is indeed important. That's why I've always said mediate, do not litigate. And frankly, the collaborative law process, because it could lead to litigation, is something that should not be your first consideration. Thank you. Martin Rosenfeld, Fair Lawn, New Jersey.